more analysis on this new development in the MK versus IEC matter. I'm now joined by legal analyst Zola Majavu. Mr. Majavu, good afternoon. Thank you so much for your time. I want to start with a comment that was made this morning by a former IEC commissioner, and that's Terry Tselane. In his view, the IEC's decision is, quote-unquote, ill-advised. He also doesn't understand the panic. And he says quite categorically, they've got it all wrong. Your view?
Good afternoon and good afternoon to your viewers. With respect, I do not agree with that view. The IEC is a party to a matter in which a decision was given. It is, for whatever reason, aggrieved by that decision, and it is open to them to approach a higher court for further redress or clarity. It doesn't matter what we may personally feel about it, but they are legally entitled to taking the step that they did. So is President Zuma and the MK party, or even the original objector, to the extent that they were implicated by this court decision. So at the level of legal procedure, there is absolutely nothing wrong. And I do not agree with my brother Terry on this one.
Interesting. Indeed, because you heard what the spokesperson of the MK party had to say around the reason that the IEC has given, for taking this extraordinary, this step, that it wants clarity on Section 47(1)(e) of the Constitution, and adds to that public interest and the fact that it wants certainty on the proper interpretation of that section.
Look, firstly, let us look at the requirements for directly accessing the Constitutional Court and leave politics aside for a second. One, is there a legally justiciable matter that implicates on the Constitution? The answer is yes. Were they a party to this matter? Yes. Is this matter urgent? Yes. Is this matter sufficiently of a public interest nature? Not what is interesting to the public. It is no doubt a matter of sufficient public interest. It also has to do with the interpretation that the IEC itself made of Section 47(1)(e). They interpreted in a particular manner. They stuck to their guns until someone took the matter to court. The electoral court said they got it wrong. So clearly there are different interpretations linked to this very important a clause in an act of parliament. So who is better positioned to give clarity to that except the courts themselves, and in particular the Apex Court? That is the reason why the matter is going to the Apex Court. There may be other underlying motives that people are reading into it, especially politicians. I stay clear from such. I just stick with the law and my understanding of the law. So I do not think that the IEC can be faulted for going to the Constitutional Court to seek clarity. The issue here is, and what I think is throwing all of us away or off the ball, is the fact that unfortunately in this instance, the Constitutional Court was the court of first and final instance, and it is its own order that was not complied with for whatever reason by President Zuma. And because of that, President Zuma did not have the further appeal rights that he would ordinarily have had if this matter had been processed in other lower courts in the normal course. So to the extent that there is a further proviso that says the sentence that may have been given is of a particular nature, that sentence will not take effect until the appeal processes had been finalized. But in this instance, after the ConCourt had spoken on the matter, where else could President Zuma have gone to exercise his appeal rights? So these are serious legal intricate matters that need to be resolved once and for all. And I think the IEC is correct. Whether they got it right or wrong in the first place, I'm one of those who believe that they bit more than what they could chew. They stepped outside of the province of their mandate. Maybe I'm wrong, but maybe they are right. But it doesn't matter. The court of final instance, in this instance, is the Apex Court. The ConCourt is the one that will pronounce definitively on the matter. And then everybody knows either the MK party is right or the IEC is wrong. But you need legal certainty, and you can't get it from legal commentary or the Twitterati. It must be pronounced upon by a court of law.
Now, what bearing does it have? I mean, does the fact that the court, the Constitutional Court, was the one that sent the former president to jail in the first instance?
This is precisely where the quandary is, and it is unfortunate because, as a fact, that is what happened. And that is why I was one of those who aligned myself with the minority view of Justice Jafta on the matter, because we are now deprived of the opportunity of further appeal processes that would have been available to President Zuma had this thing happened in the normal court. So this is quite a unique and a novel matter, because the ConCourt got itself into a situation where it was both a court of first and final instance. You are right, the observation is correct, and that is where the detail is. And I think that there are better places to resolve this mess for all of us once and for all. But to blame the IEC for approaching the apex court is a bit unfortunate.
What could those places be, the better places where this matter can be resolved?
That's why I'm saying the better place would have been the apex court itself, because there is no other judicial authority beyond and above the apex court. Mm-hmm. That's why I am lamenting the fact that we are in this mess because the Constitutional Court, for whatever reasons, acted as both the court of first and final instance. And that is why we are in this particular predicament. However, they are still the only place legally seized with determining matters of this nature. And someone may argue that, are they not conflicted? Maybe they are. But where else can this matter be resolved? Because we have a judicial hierarchy in this country, and the apex court is none other than the Constitutional Court. It may well be that maybe the constitution of the court may be arranged in such a way that those who sat at the time when this decision was made are recused, and then the court is constituted differently. I'm not sure how many non-involved Constitutional Court justices are available. Does it mean that there may be other acting judges appointed to try and deal with the notion of conflict? Nobody knows. But the fact of the matter is, structurally, the matter must go to the Constitutional Court, regardless of the quorum.
Mm-hmm. Assuming, the IEC is acting with the noblest of, intentions here. What do you think, hypothetical, of course, what do you think would have happened if it had just let this matter slide?
We would have been deprived of the benefit of certainty, because if something like this were to happen again in the future, chances are they may well interpret the law the way they thought was correct, or the way they may have been legally advised, which they say they were in this instance, and then we're back to square one. So judicial certainty, I think, is important, not only for the current participants, but for posterity. So I think precisely because of what you are postulating, all the more reasons why they had to go to the ConCourt. In fact, the objector himself could easily have done that, assuming that he was aggrieved by the decision, and the ConCourt would still be the place to go. It is still the place to go regardless of who takes the matter there, because in terms of our judicial hierarchy, there is no other place where this matter can go. There is an argument that the IEC should have let this matter to be decided by the National Assembly. That argument is also plausible. But on the other hand, the IEC may say, we are the custodians of the process of enfranchisement and the entire election value chain, and we have a duty to ensure that those who actually end up in the National Assembly are those who are not disqualified. Mm-hmm. But someone may say, but it's not your business to do that. Let the National Assembly do what they have to do. Mm-hmm. So it cuts both ways. So I don't even know where I am sitting right now, who between the two parties is correct. However, I am aligning myself with the decision of the Electoral Court. The 5 bench judges, I think, got it wrong on their strict interpretation of the law. But to the extent that the IEC seems unhappy about it, regardless of their motives, I think it's only fair that this matter should be ventilated again before the apex court, and then you have final clarity.
Quick last one, Mr. Majavu. I mean, does it matter? Because, I mean, both the MK party and Mr. Salone have raised this issue when they've been talking to us today, that why was it necessary for the IEC to do it now, before the electoral court makes public its reasons for its ruling?
Of course, hindsight is always the best science. It may well be that they could have erred on the side of caution and seek clarity before they acted. But remember, the IEC said that they sought legal advice. The courts are not there before a live matter is raised to give judicial advice. The courts are there to adjudicate over a dispute. We now know that a dispute has happened, and that dispute is the conduct of the IEC in interpreting Section 47(1)(e) in the manner that they did. We now know that they've been told they got it wrong by the electoral court, but we do not know what the reasoning underpinning that decision is, which is why they are in a bit of a quandary, because I would imagine that they had some difficulty. This is the IEC in fashioning and crafting out their grounds of appeal without the benefit of the reasoning of the courts. But be that as it may, I do not think there is any moment to a suggestion that the timing seems to be suspect. From a politician's lens, that may well be the case, but legally, we would not be faced in the legal fraternity about this particular step. But I stay away from what politicians may make of it. Maybe they are right, maybe they are wrong, but that's not my place.
Mr. Zola Majavu, thank you so much for your time and insights.